Okay, we are just past the top of the hour, so we will go ahead and get started. I want to welcome everybody to today's Heartland Telehealth Resource Center Education Series. We're glad you're joining us for this webinar today focused on telehealth billing, coding, and policy. Just a few notes as reminders. This session is being recorded and we will share it with you afterwards, along with additional materials. Your microphones have been muted when entering the Zoom. So please unmute or use the chat if you have any questions. We will be monitoring the chat box during the webinar. Your completion certificates will be emailed, and it's important to sign on with your first and last name so we can identify you. Please rename your Zoom profile by using the 3 dots on your Zoom screen if your full name isn't visible. So we'll go ahead and get started. I'd like to introduce Rochelle Marting. Rochelle is a local attorney who is also a registered health information administrator and certified medical coder. Her practice focuses on medical coding, billing, and reimbursements, HIPAA privacy and security, health information management, and regulatory compliance. We're thrilled to have her here today to talk about guardian responsibilities and issues surrounding consent, privacy, service delivery, and billing in the telehealth context across the lifespan. Now I will turn it over to Rochelle.
Great, thanks, Molly. Before we dive into the topics of consent in telehealth and privacy and issues surrounding, I would say even more broadly than guardians, personal representatives of the patients themselves that are being treated by telehealth. I wanted to remind everyone, if you hadn't seen the news already, that the federal public health emergency was set to expire on April 15th, and it was renewed for another 90-day period. So as of right now, the current renewal period would take us into mid-July. And I think the next 30 days are going to be really critical in the federal public health emergency, because we've got a notification from the Department of Health and Human Services last year that they were going to try to provide at least 60 days notice before allowing the public health emergency to expire. So hopefully within the next month, we will have a good indication of whether this is the last 90-day cycle in the public health emergency, or if signs are pointing towards July being the date that it would be allowed to expire. The other reminder is we had a pop-up webinar. I think, Molly, you may have some information on that you can share at the end of the session on the Consolidated Appropriations Act of 2022 and what it means for extending some of the telehealth flexibilities that we've had during the public health emergency for a period of time after the public health emergency ends, whether that's July or if it's renewed another 90 days or even longer. And so look at that, watch that webinar for the flexibilities that will remain for 151 days after the public health emergency ends versus those that will go away the day the public health emergency ends. And then we've got rules under the Medicare physician fee schedule where some services and some flexibilities will continue until December 31st, 2023. So lots of moving targets and deadlines and dates related to telehealth in the coming months, as we expected once the public health emergency was winding down. So I want to jump into starting kind of the basics of consent. And today we're going to talk about getting consent for a telehealth service, or really for any service, whether it's telehealth or not. Some of the basics on who can consent, the nature of consent, how you get consent, when you get consent. So kind of the who, what, where, why, when of getting consent for services, as well as some specific rules on consent for telehealth. In Kansas and Missouri, for those of you in those two states, the State Component Association for HEMA has a legal manual for HIM, and there's a whole chapter in this manual on consent that I helped write. So I pulled a couple of quotes and citations from those manuals for this presentation. And one of the basics, I kind of like this quote that serves as sort of the reason that we're getting consent in the first place. Every human being of adult years and sound mind has a right to determine what shall be done with his or her own body. And then we're going to talk about some of the situations that may even have some variations on that quote of adult years and what it means to be of adult years in circumstances when individuals who may not reach the age of majority, depending on the state law, may still consent to services on their own without a parent or without a guardian. We're going to talk about what it means to be of sound mind and what happens if we have an individual who has reached the age of majority, an adult who may not be of sound mind to be able to give consent for services and how we approach those. Then I'm going to talk about once we've got the appropriate consent to give a service from the right person, we've gotten consent at the right time, we've documented it the right way. During the delivery of the service, some privacy considerations, depending on the nature of the service, the individual that the service is being directed to, when we may have parents involved or other legal guardians, when we may have an individual that needs or has durable power of attorney during the session. And then after the session is delivered, what we do in terms of releasing that information and who we can share information with. So we're going to kind of go through the cycle of care delivery and who can or needs to be involved at those different stages. So that's kind of the quote from Judge Cardoza on the philosophy behind consent, but it's not just a theory or a good practice. To get consent, it's actually required, and it's required from a number of sources. So one of the primary sources at each of our state laws goes back to our individual professional disciplines. So physicians, physician assistants, nurse practitioners, physical therapists, all of those types of professionals who have licenses or certifications or registrations under state law, they may have by statute or by regulation requirements to obtain consent before providing services. And if you look at the example from Kansas regulations for physicians, failure to get consent can be an act of unprofessional conduct within that profession's licensing laws that can create issues if there's a complaint to the applicable licensing board. So that's one of the sources or rules or requirements on why we're getting consent, in addition to it just being a good idea. But the professional associations for each of those disciplines also has codes of ethics for their members. The American Medical Association, for example, the largest national association for physicians, has a very detailed code of ethics, an entire chapter dedicated to consent and the way that physicians should get consent from who, how, and when. So it's detailed there. And I say that, although that's not a binding source of law, in the event services are rendered and consent hasn't been obtained from the right person at the right time in the right way, though that code of ethics can be used if there was any kind of litigation or dispute as evidence of what the standard is. And the standard becomes important if we're talking about negligence, because we always look to what the standard is. And those types of professional association guidelines are very likely to be used as evidence of what would be expected for individuals in that profession. So other professional associations for physical therapists, for physician assistants, even specialty societies within those disciplines may similarly have codes of ethics that we need to think about that create the standards on the who, what, where, why, when of getting consent. If you're coming at this from a facility standpoint, like a hospital, a community mental health center, rural health clinic, FQHC, ASC, the facilities have licensing requirements also, distinct and separate from an individual professional's licensing requirements. So for example, RHCs, under your Medicare conditions of participation at federal law, you have to, for each patient receiving healthcare services, the clinic has to maintain a medical record that includes documentation of consent or evidence of consent forms when those are needed. And then we have payer-specific or even service-specific requirements for consent. So for example, those of us in the Kansas City area, the Blue Cross has a policy in its provider manual that members have certain rights to give informed consent to treatment. failure to have consent could result in denial of payment. When I say service-specific requirements, there's a whole category of services under Medicare that we've talked about in previous sessions, care management, and a requirement of all services that fall within the care management category require consent, in part because they may not be face-to-face services with the patient. So transitional care management, chronic care management, things that may be happening kind of behind the scenes without the patient directly involved at each point that those services are being provided, but there's still patient cost sharing. And so Medicare wants the patient to know about that and consent to be involved in those services and to be billed for those services. So that's sort of our why. Yes.
Sorry, I was wanting to catch between slides. We do have a question about the previous slide. Is it okay to assess but not treat if no consent? For example, initial evaluation, but no prescription or treatment is provided. You touched a little bit on it towards the end, but maybe if you could clarify a little bit. I guess you're
perfect. It's a perfect segue into the next slide as well. So it's actually right here on the first bullet point. So that's a good question. Can you assess a patient without consent if you're not necessarily prescribing or treating, ordering tests or other procedures and services? So there are situations when you can proceed with an evaluation or treatment of a patient truly without consent. And I would say, even in those situations, like an emergency, right? A patient's coming into an emergency department, they're unconscious. They're not able to verbally give consent or to sign a consent form. But this first type of consent is implied. Unless we know through like a DNR that they don't want to be resuscitated, or religious beliefs like a Jehovah's Witness where we know they may be opposed to certain blood or blood products. Those types of situations, we can infer consent is implied in those types of in emergency type situations. So in the telehealth context, if a patient requests a telehealth service, you both connect to the telehealth service and you begin the telehealth service, right? There is implied consent to undergo that evaluation. So it doesn't necessarily mean that you have to have a written consent form each and every time you have a service with a patient. I'll say that sort of with an asterisk though, because depending on your provider type and your facility licensing rules and your professional licensing rules, you want to look to those to see if you need to have some sort of consent on file. And that could just be a general consent to evaluate, a general consent to treat, rather than something specific. But there is a concept of implied consent, and telehealth or coming into the provider office, sitting in the exam room and having that conversation with the healthcare provider can imply consent to undergo that evaluation. There's lots of variables we could talk about down towards the end of this slide. If we have patients who are involuntarily committed, there may be certain evaluations that the patient's not agreeing to, but we are able to do for a limited time during that involuntary commitment. So I guess the short answer is yes, you can typically do an assessment under implied consent. Generally, it's a great idea to have a general consent to treatment on file in the record, but look to your particular provider type and any licensing requirements of your facility or your organization type, your payer requirements as well, to see what you have, what documentation requirements you need for that.
Additionally, I don't know if you saw the chat. Additionally, with that piece, there was what about an instance of a nursing home patient unable to consent and they're asked to evaluate until consent received from responsible party?
Okay, so we've got a patient who is unable to consent on their own due to maybe incapacity or the inability to give informed consent, long-term care setting, and the legal or personal representatives may not be available. Depending on the nature of the assessment, if it's not invasive. We're not doing any procedures on the patient. Most likely you've got a general consent to treatment on file in your admission documents. If not, that may be a process that you put in place in your registration and admission paperwork to the long-term care facility, that general consent to treat signed by a personal representative of the patient. If not, if you don't have that general consent to treatment and personal representatives are available, but based on professional judgment, the facility and or the healthcare provider believe that there needs to be an assessment, that's probably going to fall under this first category of implied consent. If we need to intervene, if we need to send them to the hospital, if the patient needs a procedure, then we may need to get specific consent from the personal representative or someone who is able to consent on the patient's behalf. Consent can be verbal, right? So the patient, I always think of coming into the exam room or joining a telehealth session. You can ask the patient, do you agree to a telehealth service? And the patient can say yes. That's a form of consent also. It's a great idea to document that in the chart, that verbal consent has been given. That's the type of consent that we often get for that category of general care management services that I mentioned. So if during the telehealth visit, you talk about a patient's chronic conditions, and you say, Rochelle, we've got this program where we can monitor, we can give you a call, check on your medication compliance, we can check on your lab values. There is a patient cost sharing amount to that. Would you like to participate in that program? And we could be having that conversation with the patient via telehealth, and patient Rochelle says, yeah, sure, sign me up. So we can document Rochelle's consent, and that can meet the service specific consent requirement to participate in that program. Then, of course, the very best way to get consent in terms of being able to prove the consent was given is written. And there's a couple of different ways you can get written consent, and there's a couple different types of written consent. There's that general consent to treatment that you often would get for new patients to your practice or to your facility as part of your admission or your registration paperwork. It's not specific to any particular type of procedure. It just says, generally, as needs arise, you, the patient, or legal representative of the patient, give consent for us to assess, to evaluate, to maybe prescribe or treat the patient as necessary. But then if the patient needs something more specific or more invasive, like a procedure or a transfer to another healthcare setting, so the long-term care setting, transferring them to acute care if that's needed, those may be situations when at least verbal, if it's an emergency, or written consent may be needed. And then we get specific consent for that service that we're getting ready to provide to the patient. So an in-office procedure or a major procedure in the hospital setting may be examples of when we get a specific consent where we talk to the patient about what that treatment is going to entail. And I'll talk a little bit about what the scope of what we want to see on specific consent in just a little bit. So I talked about another example of service-specific consent can be found in the hospice program as an example. So before a patient elects hospice care, which is generally palliative care for a patient who has a terminal illness, where we're not trying to treat or cure a patient's condition, we're trying to keep them comfortable. And so there's a requirement that we get a written consent with very specific content requirements to make sure the patient understands what they're getting into when they elect hospice care. One of the things to consider in your consent forms is that we want to make sure it's in understandable language. So we want to make sure it's not written with a lot of medical terminology, that it's not written with a lot of legalese, like a contract, but it's written in a way that patients can understand. So it's readable. It's not in size 7 font, it's in 10, 11, 12 point font that's easy to read, that's easy to understand. And we also want to take into consideration individuals with limited English proficiency. We could probably have a whole session on that topic alone, but back in, I want to say 2015 or 2016, there were guidelines put out on individuals with limited English proficiency and how healthcare providers need to have translation services available. And if your consent form is in English and you're giving it to an individual who doesn't speak English, signing that form is not going to provide any protection for the healthcare provider because the patient can't read and understand its terms. They're not truly giving informed consent. So that may involve having translation services available. It may involve having your consent forms available in different languages if you have large patient populations who speak different languages. But we have to make sure that the terms and the information are understandable for the individual patient. I'm going to address a question here in the chat. It says, what about an intentional re-entry housing with community service learning project where participants are having mental health issues, they don't have insurance, we need access to multidisciplinary professionals who can meet with us in a support group type setting and help the non-insured individuals find the professional level of trauma-informed care and other mental health services. So Helen, that's a great question. And maybe you can, if you want to unmute your mic and talk about this scenario a little bit, I can talk about some of the consent issues that you might want to think about in that setting for individuals with mental health issues coming into that environment.
Thank you so much, Rochelle. This gives me hope that I may actually be able to get connected to the backup needed. I'm a retired nurse, had a 40-year career and was one of 13 nurses in Kansas trained as a child care health consultant. I also came from a school nurse background and worked all 40 years in family-centered, community-based, mostly rural situations. And, you know, now that we have internet and we can work from phones, and this campus here in Waterville, our hub is interestingly was the town hospital for 33 years. So when I was involved as the cardiac rehab and rural nurse generalist over at Onega, 1986 to 2005 or so, we were on cutting edge of telemedicine, telehealth. And so it's a natural extension that I wanted for quality of care in these little rural communities, which this town of Waterville is only 650 people. And even though there used to be doctors and dentists and eye doctors here, there aren't now. And this is not an institution. This is quality care for people who have aged out of the foster care system. And I'm having to deal with their unprocessed trauma and whatever is triggering them, you know, and I help people that want to get off alcohol and drugs because this is a safe base. I don't want that stuff around. I don't want it modeled for children, how, you know, adults have to cope, with real life by having beer or tobacco. So anyway, thank you for letting me have my rant and knowing the predicament that I'm in. If anybody on here wants to get involved with the Wellness Weavers system, all you have to do is donate like an hour of your time to collaborate online with us. And we have the Everyone Counts game show. So 4 of my 20 scholarships were to the Association of Applied and Therapeutic Humor. I try and make edutainment a way to help reach people, to help them get to, lots of toolkits, lots of tools in our toolkits to get to calm so that they can collaborate and innovate. But I can't do it alone. This is Wellness Weavers was not meant to be a one-woman show.
That's right. That's right. You've got your work cut out for you. Well, it sounds like, Helen, what you've got individuals that If they have reached the age of majority, we have a default that they can consent to care and treatment. If they're not competent to provide informed consent, there may be different avenues still. If we go back to this slide, if there's no one else to consent for them because they don't have a legal guardian, they no longer have a parent necessarily help making those decisions for them, and they don't have a durable power of attorney or durable power of attorney for healthcare decisions, sometimes that consent to treatment can be implied, or it can be obtained at a moment or at a point in time when they are competent and capacitated enough to decide to participate in the programs that you've got. So thank you for telling us a little bit about that program and the type of consent issues you have.
I thought that working with probation officers would give me a system of checks and balances, but when they just merely text the people and they meet away from me, I don't get a chance to give my perspective, so it keeps perpetuating. It's kind of like herding cats, as they say,
That's right. Well, as we go through this, there may be some other consent and issues with the personal representatives that may raise questions for you. So stay tuned. There might be more on these next couple of slides here too. So we've kind of touched on this a little bit already on who may give consent. When we have, of course, a competent adult, as Judge Cardoza said, a competent adult of sound mind can give permission on what happens to their body and what type of treatment, services, and assessments they do or choose not to undergo. So we've got the patient themselves or a legal representative. And there's two terms that I want you to keep in mind. In terms of consent, we use the term legal representative, which might be a parent or a legal guardian of a minor. It might be a durable power of attorney or a durable power of attorney for healthcare decisions for an incapacitated adult. When we talk about privacy and sharing information, the terms that you're going to see is personal representative, but they really are one and the same, as someone who has the legal authority to stand in the shoes of the patient in terms of consent or sharing and receiving information related to patient's healthcare. So for minors, most of the time that may be mom and dad. For individuals who may have one or both parents who no longer have legal custody of the patient, that might be changed a little bit. There may only be one parent who has legal custody. Both parents may have joint legal custody. And so what that means is, like, my husband and I, either one of us could consent to treatment for our children, right? We have joint legal custody as a married couple with our children. If in the separation or in the divorce process, there is a court order that redefines that legal custody, that ability to make legal decisions for the minor, that might be impacted. And so even though my husband and I are both biological parents to our children, if we were to divorce and a divorce order says he has sole legal custody of our children, then he is the one that can make the healthcare decisions for them and not me. Even if I have joint or partial physical custody, even if they can come visit me, I may not, depending on the way that court order is written, have legal custody to make decisions. So in those circumstances of parents that are separated or divorced, we really have to understand the nature of legal custody under the divorce decree to understand which parent can consent or which parents can consent. Legal guardians of a minor child could also make healthcare decisions for the minor. And then we'll talk a little bit about individuals in foster care also in just a bit. So for incompetent or incapacitated adults, if it's an emergency situation, we may have to rely upon implied consent to assess or to treat that individual. In the telehealth context, for example, neurology consultants may have a telehealth visit to assess for potential signs of stroke or other types of neurological conditions. And if the patient can't consent and we don't have anyone else else available, we may be able to imply that the patient would consent to that assessment or to that evaluation if he or she could do so. And then we have durable power of attorney for individuals. So these are formal legal documents where a patient designates one or more individuals who can make decisions for them. So I want to kind of break down the power of attorney just a little bit, and we'll talk about this more in additional slides as well. But a power of attorney is simply someone else who has the power to make decisions for someone or with someone. That can happen even while an adult is capacitated and has capacity to make decisions. So I right now could give my husband power of attorney over bank accounts or financial decisions, right? That can happen even while I have the ability to make decisions. A power of attorney is durable if it continues even after I no longer have the ability to make decisions. And that can be on a temporary basis, temporary incapacitation. If I were in a car wreck and on a ventilator, that my durable power of attorney could make those decisions during that period of incapacitation, even though hopefully I recover and am again able to make decisions on my own. Or that durable power of attorney could continue if I'm permanently incapacitated and unable to make decisions on my own, as we tend to see with elderly patients who are no longer able to make decisions on their own permanently. There's also a difference between a durable power of attorney and a durable power of attorney for healthcare decisions. DPOAs tend to make financial decisions or help make financial decisions for the individual. They may not necessarily be able to make healthcare decisions like consent to treatment, consent to withholding treatment for the individual, unless there is a durable power of attorney for healthcare decisions. They can be the same individual, but they are not the same designation. And they're two different legal documents. We also, to complicate that even more, may have more than one individual who has been designated as a durable power of attorney or durable power of attorney for healthcare decisions. So I'll talk about that in just a minute. So let's talk about consent and minors just a little bit more. We've talked about legal guardians, a court-appointed legal guardian, or parents who have legal custody of a minor child can generally give consent. Talked about the divorced parents and how we really need to see the divorce decree to understand who has legal custody of the child. If a parent simply says, I have joint custody, that's generally referring to physical custody and visitation rights. It may not necessarily refer to joint legal decision-making custody for that minor child. So we have to look at those documents to understand who has the right to consent to what healthcare for the individual. And sometimes in those divorce decrees now, I'm even seeing attorneys write those in a way that only one parent has access or the rights to the child's medical records. We may see that, for instance, if there are potential allegations of abuse or neglect, where the potential abusive parent or neglectful parent may not have been given the rights to medical records because it may have information about the child and that particular parent in the medical record. That becomes really tricky if a document is written in a way that one parent is not entitled to the medical records, but is financially responsible for paying for healthcare services under those divorce decrees. And that happens. So we may be asking for payment, but unable to produce the medical records to prove that a particular service was provided or to show the details of what was provided. And then Helen mentioned that she used to work in the school district. And that's a good example of this third item, adults standing in loco parentis for a child. So children going to school, there might be a certain level of consent to assess or treat a child during an emergency or an urgent situation when the parent's not available. If a child had an asthma attack and in the school's judgment needed to be transferred to a hospital, it's possible that consent, that temporary consent in an emergency situation could be given by the school if the parents couldn't be reached. Or if your children are like mine and are constantly getting hurt at recess, falling off the monkey bars, there's in loco parentis, the school nurse can assess the child, could put an ice pack to help some of those injuries in those types of situations. Now, there are situations when minors can consent to treatment on their own. They don't need mom and dad. They don't need a guardian. They don't need anybody else to consent to that treatment. Generally, if a minor is emancipated, so they have a legal order from a court declaring that they are legally able to consent and enter into contracts on their own, or minors who are legally married, or minors who themselves have minor children, can often make decisions on their own healthcare in those situations. Children in foster care typically will have a medical consent form signed by their biological parents, which gives the foster care providers the ability to take the child in for care and treatment and produce the consent that's been provided by the biological parents for that care and treatment. So for our 3 states that are primarily on this call, Kansas, Missouri, and Oklahoma, here are some examples of when minors can consent to treatment on their own with no legal guardian, no parent making those treatment, giving those treatment consents. Generally, treatment for minors over a certain age, so Kansas, it's 16, may be able to consent to certain hospital, medical, or surgical treatment procedures on their own. Missouri, we've got an example where minors could consent to treatment for their minor child. They can consent to assessments and treatments that may be pregnancy related, venereal disease, drug and alcohol abuse. Oklahoma has some similar rules surrounding when minors could consent to certain types of treatment on their own. And the important thing that we'll talk about in just a moment is that when a minor consents to services on their own and legally can consent to services on their own, the minor owns that information. They not only can consent to it, but mom, dad, legal guardian, another person responsible for the minor does not own that health information and may not be able to receive copies or access to that health information to which the minor consented on their own and legally can consent to on their own. Now, Missouri has a concept called a relative caregiver, someone that the patient lives with, who is the caregiver for that patient, who can consent to healthcare treatment for that individual. So I think of a child who lives with grandma and grandpa, for example, or aunt and uncle, and the relative caregiver can then consent to treatment, but there's an affidavit that's required. And if I won't go through all of the bullet points on what has to be included there. There's a link on this slide where you can see what that affidavit looks like. Excuse me, if I go back to this slide, there is a particular form that this affidavit needs to be substantially matching what's in the relative caregiver statute in Missouri. Now, Missouri it has a state law that because there are all these complexities and who can consent and under what circumstances, and mom and dad and whether they do or do not have legal custody, et cetera, that if a provider is acting in good faith and they're reasonably relying on someone's representation, like mom or dad saying, I have legal authority to act, to give consent for my child, and the provider doesn't have any indication to the contrary, that those representations are not accurate, then there is an immunity that Missouri law would permit the provider to rely on those representations in terms of consent. There's also a really good resource that I included on these slides that shows kind of Missouri consent laws and who can consent in what situations for different patient ages. So I'm going to switch gears and we'll talk about sort of the other end of the spectrum for individuals who have reached the age of majority in the particular state, and how we handle situations when those adults are incapacitated or unable to provide informed consent in a particular situation. So we're first concerned about capacity. And if the provider, in his or her professional judgment, believes that the patient is able to understand the nature of the assessment, the treatment, the risks, the benefits, the alternatives, that's really the standard or the threshold that we're thinking about on whether they are capacitated or able to provide informed consent for the service. If not, then we look to individuals who can provide that consent on behalf of the individual. So again, that might be a power of attorney, someone who can help make decisions while the patient still is capacitated, like financial consent, if we're having a phone call about paying for the telehealth service. A durable power of attorney, someone who continues to have that authority to help make decisions for the individual even after the individual has become incapacitated. And then a durable power of attorney for healthcare decisions that's really focused on consent to treatment, to assessments, to evaluations, to tests, or even withholding treatment and tests and services for an individual. Now, at law, a durable power of attorney or a durable power of attorney for healthcare decisions has to act in the patient's best interest. They have a fiduciary duty to act in the patient's best interest, and they also have a responsibility to honor any advance directives or living will of the patient. So if the patient says, I would never want to be on mechanical ventilation or life-sustaining treatment or have a feeding tube that's providing nutrition solely for the purpose of prolonging life or prolonging, I guess, the dying process. If that was written by the patient while he or she was capacitated and able to make those instructions, the durable power of attorney for healthcare decisions cannot invalidate those instructions that the patient made while he or she was able to do so. So a few other rules for consent with respect to telehealth in particular. In Kansas, when the patient consents and the patient has a primary care provider or some other treating physician, the telemedicine provider has to send a report on the telemedicine service, like a progress note, to that primary or other healthcare provider within 3 days of the telemedicine service. Missouri, specific to telehealth providers have to obtain the patient's consent or a guardian's consent before the telehealth services are initiated, and has to document the patient's consent in the patient's file or chart. So when we talked about implied consent as one way to get a patient's consent, in Missouri, then we have this regulation and this statute that consent has to be obtained before services are initiated. And that's kind of a fuzzy interpretation. That some might say that means before you connect to the telehealth service, because connecting would be initiating the service. So maybe the patient has to consent or fill out some type of consent before you actually connect on the telehealth service. Some may interpret that to mean you connect to the service, but before you begin the telehealth session, you get the patient's consent to proceed with telehealth. And that we have to have that in the patient's chart. But again, it doesn't say that this has to be a separate form that's signed by the patient, that this could be verbal, or it could be an electronic consent that the patient completes. And then in Oklahoma, I didn't list it out on the slide here, and I apologize to those of you that are in Oklahoma. You have a rule about obtaining consent for patients that are receiving telehealth services, specifically within the school setting, and that has to be documented in the record.
Rochelle, there is a comment with clarification in the chat box. In many cases, a DPOA may be effective immediately on execution. In other cases, they may be triggered by incompetence and then need to look at definition and how triggered?
Exactly. I'm glad you pointed that out, because there's sometimes a misconception that a durable power of attorney, the person who has been designated as a durable power of attorney, cannot make decisions for the individual unless and until that individual is incapacitated. And that's not necessarily true. When we have a competent adult, that competent adult can always make decisions on consent or withholding consent for treatment. And so even if there's a durable power of attorney document in place, they can't say, well, Rochelle said, no, she doesn't want to have a telehealth service, but yes, I want you to conduct this telehealth session anyways. However, durable power of attorney documents, they can give authority, for example, on financial decisions and payment decisions before an adult becomes incapacitated. So again, right now, I could have my husband designated as my durable power of attorney. And if he's got that authority to make financial decisions, you may be able as healthcare providers to talk to him about payment for services, paying the bill, and those types of decisions. And that could happen, that could be triggered now. Or durable power of attorney documents could be written in a way that the durable power of attorney's authority does not get triggered until I become incapacitated, which, great point, we then have to look at the durable power of attorney language, each individual document, to see how incapacity is defined and confirmed. So for example, that might be a determination by the principal, the patient's primary care physician, or it may need to be a decision by two physicians licensed in the state where the patient's located. It can be written all kinds of different ways. So we do have to look at what we need to do within that individual's durable power of attorney document to confirm incapacitation that may trigger the power of attorney's rights and authority. And that can be unique to each and every document. So we need to take a look at those documents to see what we have to do to confirm incapacity and who can make decisions for the individual.
For a general treatment consent, they include a telehealth consent, a consult consent, and what I believe is behavioral health consent, along with a general treatment consent. Is this okay to cover future services?
Yes, and when you have a general consent at the initiation of treatment or the provider-patient relationship, there doesn't need to be a time designated on that consent. So that's saying, as long as you're working with us as your healthcare provider, your physician, your clinic, you're giving us consent to these things. And then if the patient needed a procedure or something beyond the scope of that general consent, to assess and consult, and I think you said behavioral health, then we may need to get different additional consent at that point in time. We could probably spend an hour just talking about powers of attorney and all of the different ways that they can be created. There are concurrent powers of attorney where you may have two people designated as the decision makers, or one or the other could be the decision maker. You may need I've got someone in my family that has 3 individuals designated as a power of attorney, and they have to provide unanimous consent. So we really have to look at the language of each individual power of attorney. Some are written as successive. So Rochelle is first. If she's unable or unwilling, then her sister is next. If she's able or unable or unwilling, it might designate another individual after that. So then we move into some privacy considerations when the session is actually being rendered. One thing I want to point out during the public health emergency, which we're still in and has been renewed, is that there was a misconception that potential penalties for HIPAA violations or HIPAA breaches were waived. That's not necessarily true. The Office for Civil Rights, which is only one of several enforcement agencies for HIPAA, did issue a notice that it would waive its discretion to enforce any violations or penalties that may be a result of non-compliance with security rules based on the platform that you use for a telehealth service, so long as it was not a public facing platform. So if you use like Facebook Live, which is broadcast to everybody, that's not okay. But if you were using a Zoom platform, that maybe the free version of the platform that doesn't have all the bells and whistles from a security standpoint, and something happened, OCR wouldn't penalize providers during the public health emergency for that. But HIPAA is still very much in force and effect. There are certain administrative and privacy waivers that are in effect during the public health emergency that will go away as soon as the public health emergency goes away with respect to HIPAA privacy and security. Obtaining a patient's agreement to speak with family members or friends, or honoring a patient's request to opt out of a facility directory. If we have a violation of those particular privacy rules, OCR also said that they would not impose penalties in those situations. So let me address that first piece. Under HIPAA, we can speak with a patient's friends and family members if the patient is present and has an opportunity to agree or object. So again, I think of a telehealth session. And if I'm having a session with my healthcare provider via telemedicine, and my husband's sitting right next to me, and the provider can see both my husband and I and conducts that telehealth session, I'm present. I have the opportunity to say, wait, hold on a second, and ask my friend or family member to leave. But if I don't object to that, then it's okay for the provider to share the information during that session with my friend or family member present. Distributing the notice of privacy practices. There's a requirement under HIPAA that you distribute the notice of privacy practices on or before the first date of service. If we don't do that during the public health emergency, which is often a challenge in the delivery of telehealth in particular, then we're not going to see penalties during the public health emergency. We still need to be doing that. The requirement's still in effect. And as soon as the PHE ends, we still need to be making the notice of privacy practices available on or before the first date of service. I will note also that there is a proposed rule out there that some anticipate may be finalized this calendar year that would remove the requirement that a patient has to have, that we have to have written acknowledgement from the patient of their receipt of the notice of privacy practices. So while we still have to give it on or before the first date of service, we don't necessarily have to have the patient sign acknowledging that they have received it. And that would go into effect after the PHE ends if that proposed rule is finalized. And I'm sure we'll have another session later on if that is in fact finalized. Patients' right to request privacy restrictions and confidential communications is temporarily waived during the PHE. And I've talked about the security rule piece. So at a high level under HIPAA, patients have a right to access their protected health information that is in a designated record set. So essentially in their medical record. Now that right extends to their personal representatives. So remember, personal representatives under HIPAA is really the same thing as a legal representative. So if we have a minor child, that is a parent who has legal custody or the legal ability to make decisions for the child. If we have a durable power of attorney for healthcare decisions, that's the DPOA. We have to extend that same right to access information to view or inspect the medical record to a patient and or his or her personal representatives. We can share, but I guess let me back up. We can, but we do not have to necessarily share information about a patient with friends or family members if the patient's present, has an opportunity to object, and either expressly agrees, doesn't object, or the provider sort of the same thing. The provider reasonably infers that the patient doesn't object. So that telehealth service where my husband's sitting next to me and the provider infers that because I've got him sitting next to me, I probably don't object to his participation in the session. Always okay to ask if it's okay to continue the conversation and to put that note in the chart though. In delivering the telehealth service, we want to think about the provider's environment and how it promotes privacy during the telehealth session. Lack of interruptions during the telehealth session. Nurses aren't coming in to interrupt the healthcare provider and interrupt the session, or the provider's not at Starbucks with a lot of background noise and people who can see their computer screen, etc. And privacy in the patient's environment. So if we're having a telehealth visit with a minor who can consent to that service on their own, and we're talking about behavioral health issues, mental health issues, alcohol, substance abuse, pregnancy-related issues, making sure that the patient is in a comfortable and private location where mom, dad, others are not overhearing. If they have a headset that could kind of protect the audio from others hearing, could be a good recommendation. So looking to whether other members of the household are visible or audible during the telehealth session.
Rochelle, I know we are getting towards the end, but there was one quick clarification on the consent piece. And it looks like the question would be if there's a general treatment consent once the patient enters the clinic relationship, and it covers telehealth visits like it covers an annual physical. Does it cover telehealth visits the same way it may cover an annual physical? Meaning, do they need a consent for every telehealth visit?
No. And again, I think it's a great idea to have that general consent at the outset of treatment. And then we saw under the Missouri statute how we need to have consent prior to the initiation of a telehealth service. But that does not mean that each and every time you have a telehealth visit that you need to have a separate consent. Good question. A lot of practices will have a process in place that maybe they update that annually, like the first visit each year. But unless there is a defined period of time that consent is valid, then you don't necessarily have to renew that, but a lot of places will renew it periodically. So now we're kind of shifting to after the service has been provided and some of the rules in sharing or disclosing information, not just with the patient himself or herself, but also with those guardians, those legal or personal representatives of the patient. And some special challenges can arise in patient portals when, for example, a minor child has consented to treatment on those sensitive types of issues: pregnancy, communicable disease, alcohol, substance abuse, mental health issues. And for purposes of those services, the minor owns that information because he or she can legally consent to the information on her own or his own. And so when that information is getting uploaded to the patient portal, and mom or dad or other legal representative have access to the portal, that can create some issues because it could inadvertently disclose information to an individual who does not own the PHI or have the right to access that protected health information for that particular service. So a lot of places will turn off the the parent or legal representative access at a certain age, like 15 or 16, unless the minor gives consent. However, we also want to keep in mind that there are information blocking rules, and information blocking is a new set of statutes and regulations that sort of works in parallel with HIPAA, where HIPAA says we're going to use the minimum information necessary, but information blocking says we're going to share information unless we are prohibited from it. And one of the components or pieces of information blocking is that we make information immediately available to the person who has the right to that information, like a minor child who has legal authority to consent to the services. Having personal and legal representatives, and again, particularly with minors, can be challenging when it comes to the bill, because often the minor who may be consenting to an evaluation and treatment for pregnancy, communicable disease, alcohol, substance abuse, mental health issues may still be on mom and dad or someone else's health insurance. And so when they come in and they consent to the service, they need to know that if they're using a parent's insurance, mom and dad may get the bill and may still be able to see the nature of the treatment and the services that has been provided. So in those cases, the minor child has the right to request a restriction. So they have the right to ask that you not bill their insurance. And if the minor pays for the service in full, you have to agree to that request and not submit a bill to the insurance plan. If the minor or other individual for that matter asks that you not send a bill to their health plan, but they don't pay in full, you can, but you do not have to agree to that request for a restriction. Also think about on the patient registration paperwork that mom or dad or legal representative has filled out. It probably lists someone as having the right for the healthcare provider to leave a detailed message. And we may want to think twice about that in some of those sensitive situations where the minor may have consented to treatment on his or her own, and making sure we're not leaving a detailed message on mom or dad or other legal guardians message system, and inadvertently disclosing that information without the consent of the minor. In releasing information, and I know we're a few minutes after the hour here, but this is my last slide of content. In releasing information after the service has been provided in these unique situations where we have a personal or legal representative and we're not sharing the information with the patient himself or herself, when those representatives are asking for the patient's information, there's a two-step process under the HIPAA rules that we have to follow. We have to verify the identity of that individual. So the person requesting the information is who they say they are. Okay, so Rochelle Marting, the mother of Lydia Marting, I have to make sure I give them my identification, like a driver's license or address and phone number, something along those lines, to confirm that Rochelle is who she says she is. Then we have to verify that that individual has the authority to receive the information. So I am the biological parent of my child and I have legal custody. As long as there's no indication that parents are divorced or separated, confirming that name and the information matches what we have on the chart is fine. But if we have parents are divorced, or we have durable power of attorney for healthcare decisions, we may need additional documentation like the divorce decree, the DPOA for healthcare decisions document, to confirm that that individual has the authority to make decisions, healthcare decisions for the individual, and or the right to receive copies of medical records, because each of those documents can be written individually and uniquely. All right, so I'll pause there, and Molly, if we've got any other questions, I'm happy to answer those.
I have not seen any additional come into the, let me see. We have a thank you. Just as a reminder, I did put some items in the chat for those of you that are still on, including the link to the Telehealth Flexibilities Extension, I typed expansion by accident, webinar that we held in March. Also the link to the HTRC newsletter subscription. In case you are not subscribers, that's how we'll send out a lot of this information as well. We will also be sending the follow-up email with Rochelle's presentation, so hold tight for that. Looks like that's all we have.